All right, welcome back. So we are back to land, unfortunately, which we spent quite a bit of time on looking at the various forms of estates. And you'll recall that one of the forms of estates that we looked at was the leasehold estate, which was not a freehold estate, right? It's actually its opposition to a freehold estate. We said there's various varieties of freehold estates. The main ones are the only ones, are the life estate, the fee simple, and the fee tail, which, as we said, can no longer be created in Canada. Then we said there's a different category than a freehold estate, and that is a leasehold estate. The important thing there, first, is that it's not a freehold estate, right? So the rights that you have are going to be more limited. That's essentially what it means. So, for example, a life estate is a right to possession for a set period of time. Again, as we said, that is uncertain as to timing, the end of it, but certain as to happening. In contrast, a lease, right, or a residential lease as we all know it, is similarly a right to entitlement for possession for a limited period of time, but for a shorter and more definite period of time. There's also various consequences of that. For example, a life estate, we said, is an estate that you can transfer. So you can sell it, assign it, right, however you want. It's not necessarily going to be the case for a lease, so a leasehold estate. So again, the two operative words, right, leasehold means what I just said. Estate means, importantly, that it is an estate. So there are going to be some similarities, and there are going to be, in fact, some rules that will apply from the general conceptual framework that we saw regarding estates. Because a lease, right, it's not a freehold estate, it is a leasehold estate, nonetheless an estate. Why is that in Chapter 5, you ask? It's because it is similar to what we saw last week, or 2 weeks ago, actually, on bailments. Bailments are, right, giving someone your personal property meaning, again, right, something that's not land or buildings attached to land, so stuff, right, giving someone your stuff, generally for a set period of time, generally for a specific purpose, right, for free or for money. Same thing there. If you give someone your land for a period of time, right, generally for money, but doesn't have to be, kind of a similar thing, right? You're getting something lent to you. You have generally exclusive possession in both cases, bailment and lease, right? But more limited than what you'd have again in the context of a life estate. So, as we said, right, first, generally it's contractual, but doesn't have to be because, as we said, it's an estate, so you have the same default rules that apply, right? Usually it means exclusive possession. Okay, looks like my marker's running out on me there. But okay, so usually, as we said, it is, I'll change up the color there. So usually it is exclusive possession. I say usually not in the sense that it's not important, because it's in fact it's very important, but rather in the sense that you can have, right, some more limited entitlement to possession that will still register. So you can have multiple people having exclusive possession together, for example. You might have, right, certain very limited rights to the landlord showing up, being reserved, and that won't prevent it from being a leasehold estate. Nonetheless, usually you have something like, or something that is exclusive possession, and that, in fact, is how you differentiate it with a license, right? A license would be, so if you have, say, a grant that is to be for as long as she shall remain in possession, for example. That is not an estate. It's not a life estate. First, it doesn't have the magic words. Nonetheless, as we said under Ontario law, CPLA, you don't have to have the magic words as long as you evidence the requisite and sufficient intention to create a life estate. So it could be a life estate with something else in the magic words. However, when you say what I just said, when you say to be for as long as she shall remain in possession, right? Don't know if it was a he or she earlier. Anyway, they remain in possession. That is not a life estate because it's more limited, right? In fact, it says if she leaves, or if they leave, right, it's over. It's not the nature of a life estate. As we said, a life estate can be assigned, transferred freely, as long as, of course, it's in existence, namely until the person dies. So that would be a license. Because it's more limited in scope, in terms of time, or in terms of the scope of the rights. That's how we defined it earlier. So say it's a movie ticket, right? You have a right to show up at the movie theater, which otherwise would be trespass, right? You show up onto someone's property, they can kick you out. That's trespass. They give you a right to do that, which would otherwise be illegal. And the reason they do that is because you give them your money. It doesn't have to be, but usually is why people tolerate you. So that is a license. Why? Because it's more limited, as in my earlier example, in the scope of the rights being granted. There's no exclusive possession. You just get to go there, right? If you go to a different room, it will be trespassed. They'll kick you out. If you don't sit in a seat you're assigned, same thing. So it's limited in the scope of the rights, right? Less than exclusive possession, and it's also limited in time. So license, right, is not a property interest, as we said multiple times already. That's why the word estate is important. A leasehold estate is a property interest. It's something, for example, you can register in a land registry. It's something that you can exercise by kicking someone out, unlike a license. So license is more limited, and that's why the right to exclusive possession, as I just defined it, or something similar but really close to that, will be important. It'll be important because otherwise it would be a license, and therefore would not be, right, a leasehold estate wouldn't be an estate at all, would simply be a license, a contractual right. It's a right of a contractual nature, right, purely. So it's not an estate. It's just a contract that says, right, you get to show up there for a limited period of time. This means that, right, it's contractual, not a property interest. Of course, you can, for example, transfer or create a property interest by contract, right? Usually if you give your stuff away when you die or while you're alive, there will be a contract evidencing that. That doesn't mean that it's a contractual right. If you transfer a freehold estate or a life estate, it remains an estate. The transfer has been unnecessarily but helpfully evidenced by a written document you call a contract. In contrast, a license is not a property right, it's a contractual right. The contract is the evidence and the source, the sole source of the right, and its scope is as defined in there for that reason. Okay, then you have an example of that in the British American Oil case, which is not all that important, right? But you have a service station that allows a specific company to sell their stuff there, right? And then the question is whether that is sufficient to count as a leasehold estate as opposed to a license, and therefore a property interest. That is helpful in that, right, you can exercise various rights, right, oftentimes having to do with first getting possession back, second opposing your right to a third party. So oftentimes there will be obligations if the guy who owns the station sells it to ensure that the future owner respects your right, or the future owner will have a statutory obligation to do so. That, right, is not the case with a license, and therefore you have all sorts of issues, right? Sometimes also there will be entire statutory regimes that won't apply at all. So it becomes important when things go wrong and you're trying to claim a right that you otherwise would not have if it were characterized as a license, to the extent that the contract, as is the case in that case, is not, right, clear or fully clear in its language as to whether or not it is that. The disposition of the case is not all that important, but you have a couple of principles that come out of that case, which are, so first, something having to do with restrictions. Why are restrictions important? So you can have all sorts of contractual provisions, right? A leasehold estate can be created by contract, right? And that means you can limit it by contract, kind of like the conditions we saw. We said you can have a life estate. It's cool, right? It's big, it's pure, but then you can attach conditions to it. You can have a life estate that says, if she does something, I think it's been illegitimate children, right? If she conceives illegitimate children, then I may re-enter. That is a condition upon a life estate. That makes the life estate more limited, and that is allowed. Same thing for a leasehold estate. You can write on the piece of paper that evidences your leasehold estate that it will be limited. Same thing as the grant, right? Instead of saying to A for life, you say to A for life, but if she conceives illegitimate children, I may re-enter. You have limited an estate by contract. Again, the contract is not, right, the nature of the interest. It's a property interest, but it's transferred and, right, defined by the contractual instrument. Same thing there, right? You've got a lease. You can have certain conditions on it attached by contract. So you'll sign a piece of paper. The piece of paper will say, right, will have various restrictions in it, which is the case in that case. So you have, right, certain issues having to do with the accounting records, I think, the types of products being sold, and all of that. Why is that relevant? Because when you start having too many restrictions, you get into trouble with the earlier issue we discussed, which is that it has to have sufficient exclusive possession for it to count. And so, right, if you have too many restrictions, it won't be sufficient for it to be a leasehold estate, right? All that being a matter of very subjective degree, but at some point within that continuum, you'll have too many restrictions, and therefore it just won't be a leasehold estate, which is essentially a right to have exclusive possession and therefore do whatever you want, right? If now they're limited in what they can sell, when, where, how, and on top of that the owner can unilaterally change their mind, then it would not be, right, sufficient, and it would be simply a license. And usually it's something that's mentioned again in the case and that we discussed earlier in the term, but you have usually a license is granted for a specific purpose. Again, that's just a redefinition of what I said earlier, that the scope of the right, which is a license, is more limited. It's usually limited in scope of the rights, and it's limited in time. Usually the ways in which it's limited in the scope of the rights, as I said, is because it's for a specific purpose. For example, you have the right to show up to a movie theater for the purpose of seeing the movie on that particular night. Then you have a similar issue with the other case, the Metromatic case. Again, you have to look at the contract to see whether or not it is actually a lease. And as we'll see later on, the threshold issue, sorry, before we move on, is the same, namely that you have to have exclusive possession, or at the very least sufficient exclusive possession for it to count. Same issue there, right? You have a bunch of what we call restrictive covenants, which again impose various obligations, limit the nature and extent of your exclusive possession, and when that is upon that subjective spectrum too much, then it becomes a license. Okay, two additional issues that you have, page 421, which are pretty important. As I said, first thing, is that you can register your leasehold estate, unlike your license, because it is a property interest, right? So if you have a land registry in Ontario, right, it is a registry of interests in land, right? Read estates in land. A leasehold estate is an estate in land, and so you can register your leasehold estate in the land registry for that reason, not your license. Other thing that you see page 421 is that, and that's important, the characterization of the interest by the parties is not determinative. It's helpful, but it's not determinative. That is a principle of contractual interpretation. So, if you write lease on the piece of paper that you sign, it doesn't make it so. It doesn't make it a lease. When you have certain legal requirements, whether they are common law requirements or statutory requirements, then you have to respect these requirements for a lease to be created. It is not sufficient, right, for you to just write the word lease on the piece of paper. If you don't meet the statutory requirements and it is too limited, it becomes a license. It will be a license regardless of what you wrote on there. That's what we mean by not determinative. That doesn't mean it's useless, right? It's just not determinative. So it can be helpful, right? Because the reason you wrote that on the piece of paper is because it is your intent, right? Usually that's why you write a contract. It's evidence of the intent of the parties. And the parties signed it because of that intent, right? And therefore, the courts will use that to the extent the interpretation is equivocal. But if it's not, right, then it won't be determinative. Okay, then you get into the important stuff, which is privatey. So, okay, so this is this is going to get crowded there. Okay, so you have two types of privateys, and that is privity of estate and privity of contract. When does that become relevant? Well, privity of contract is simple in that it means there's a contract. So you know there's privity of contract when there's a contract. So, for example, if you have a lease, so you've got the landlord and the tenant assigns the interest to the assignee, which is this person there. Then you have, right, we'll use the letter K because that will be simpler. You have there two privities of contract. So you have the landlord and the tenant who have privity of contract. In other words, they have a contract because they signed one, the lease. Therefore, you have privity of contract. Why is it helpful? Well, you can sue on the contract, right? It's not complicated. If you want to show up in court, right, and you say, I want money from my tenant, we know that you're allowed to do that because there's a piece of paper that says that, right? You're suing on the contract. Then if the tenant assigns their lease to a third party, namely assignee there, same thing. There will be a piece of paper evidencing the transfer. Therefore, there will be privity of contract between the tenant and the assignee. And therefore, right, the tenant will be able to sue the assignee because they have a contract. To the extent that that contract is not respected, right, they don't pay, then they can sue on the contract. However, you've got a problem there in that, right, from that purely contractual matrix, right, forget the line there because I didn't draw it yet, you have two contracts. Then you want to have the landlord sue the assignee or the other way around. So, what if the assignee wants to have possession of the apartment because something comes up? Well, they have no legal relationship, no contractual relationship with the landlord because they didn't sign a contract with the landlord, right? Ostensibly, they'd have to sue the tenant, and then the tenant would have to sue the landlord. What they do have, which is something we just made up, which is privity of estate. Because they have an estate in the property that was transferred by contract, was transferred from the landlord to the tenant by contract, subsequently to the assignee by contract as well, you have privity of estate. They have an estate, right? They have a leasehold estate that was transferred to them after it was transferred to the tenant, Therefore, they have an estate, they have privity of estate with the landlord, and that is helpful in that it allows them to sue the landlord directly for certain things, usually to get possession back. Same thing if you have a somewhat different situation there, where you have, and we'll draw it separately, that will be simpler. So if you have the landlord, and the landlord again has privity of contract with the tenant, namely they signed a contract with the tenant. Then subsequently they sell the house or whatever it is to landlord number 2 there, right? Again by contract. So they transferred by contract to landlord number 2 the title to the property. You run into the same problem in that. Right? The tenant there is going to be unhappy because they no longer have a contract. So how can they ensure that their lease, their estate as created, their leasehold estate is opposable to landlord number 2? And if it were a license, it would not be. If it were a license, it would only be contractual. If it were a license, they just wouldn't have a right. But it's not a license. It's not a purely contractual right. It is an estate. Therefore, they do have a right as against landlord number 2, namely that they have privity of estate. They have a right to possession, which is their estate, as against the new owner of the building, which is landlord number 2. So, that allows them, for example, to sue landlord number 2 if landlord number 2 does not want to honor their lease, although the lease, again, is not a contract that binds landlord number 2. It's a contract that binds landlord number 1 and indirectly landlord number 2 because landlord number 1 entered into a separate contract with landlord number 2. If you have if you have a subtenancy, which is you assign less than you have. This example was with, as I said, an assignment. You assign your lease. That means that you transfer it fully and as is. So you transfer it for the remaining period of time in the contract for the amount that you're leasing it for. That is an assignment, and usually, right, you're fully withdrawn from the lease. And that's what this would apply to. Something else you can do is a subtenancy, and that's where you assign less than you have. If you assign it for a shorter period of time, or for, right, not substantially all of the rights that you have, then you will not have privity of estate. You will only have privity of contract. So, assignee will not have any rights, or the other way around, as against, right, landlord. It will be a contractual assignment. So, if landlord wants to get paid, they get paid from tenant number 1. Always. So, doesn't matter that the assignee doesn't pay. Tenant number 1 has to pay. And then, right, assignee pays tenant number 1. If tenant number 1's unhappy, they sue assignee. There's no suing between the landlord and the final assignee because they have assigned, again, less than they have. And we will pause there for the purposes of erasing the board.